Thank you. Mr. Ashcraft, you indicated no additional witnesses and one witness as rebuttal from disciplinary counsel. Mr. Helen, good afternoon.
Good afternoon, Your Honor.
All right, please call your witness.
Disciplinary counsel calls Laura Weingarten.
Thank you. You may be seated. Raise your right hand, please. Do you swear or affirm that your testimony today will be the truth, the whole truth, and nothing but the truth, so help you?
Yes.
Thank you. And Ms. Weingarten, you're aware of the sequestration order and the witness protocol orders that I signed months ago in this matter, correct?
Yes.
You
I
have
haven't
any-
been following them.
Pardon?
I haven't been following them because I'm here.
All right, that's right. And you are have not been called upon to be a witness until at this particular point. All right, I'm ready then to proceed. State your name for the record.
Laura, Lora, Weingarten, Weingarden.
Thank you. Go ahead, Mr. Helen.
Thank you, Your Honor. Good afternoon, Ms. Weingarten.
Good afternoon.
Are you employed?
I am.
How are you employed?
I am a staff attorney at the Judicial Tenure Commission.
How long have you been a staff attorney with the Judicial Tenure Commission?
It will be 3 years in December.
Happy impending anniversary. How were you employed before working with the Judicial Tenure Commission?
I was an assistant prosecutor for Wayne County for 33 years.
And during that 33 years, were you assigned to any special unit or units in the prosecutor's office?
Yes, for the last 29 years, I was assigned to the child abuse unit.
And what kinds of cases did that unit handle? It's sort of buried in the title, but what kind of cases did the unit handle?
Sexual assaults of children 15 and under, physical assaults of children 12 and under, baby and child homicide cases, and anytime a child was a key witness to any other kind of crime, the child abuse unit would take that case.
And during the course of your duties, were you required to interview children in connection with criminal investigations?
All the time.
Now, you heard Nancy Deal testify earlier in this proceeding, is that correct?
I did.
And Ms. Deal testified generally about the importance of following the forensic protocol when interviewing children. You recall that?
Yes.
I'd like to ask you a few questions about your own experience and then practice with respect to the forensic protocol. First, are you forensically trained?
I am.
And what does that mean to be forensically trained?
When the protocol came out in, I believe, 1998, there was a push toward getting everyone who interviews children in the state, including prosecutors, CPS workers, police officers, forensically trained. It meant taking a 2-day course and getting certified. And I took that course and I was certified, and I've been using those skills ever since.
And I'd like to take a step back from that and just have you explain, what is this forensic training? What is the purpose of it?
It's a training put on mostly by the Prosecuting Attorneys Association of Michigan. Ms. Steele was one of their trainers. And it is a training that teaches us what steps to follow when following the Michigan Forensic Interview Protocol. And it teaches also a lot about developmental stages of children and their capabilities in linguistics and emotions and things like that.
And what is the purpose of following those steps?
The purpose is so that we can get a fair, honest, non-suggestive, non-leading interview of a child. And the bottom line is we want to get to the truth without any biases by the interviewers.
Once you were trained in the protocol yourself, did you have occasion to use it?
All the time, daily.
And just give us an estimate how many times you have followed the forensic protocol during the course of your career at the Wayne County Prosecutor's Office.
So I'm taking a wild guess because I really have no idea, but hundreds, if not 1,000.
In addition to being trained in the forensic protocol and questioning children following the forensic protocol, have you provided training in the protocol?
I have. I took a class called Training the Trainers, and then I became a trainer. So
when was that?
I'd have to say the early 2000s, but I'm guessing.
Okay, approximately the early 2000s.
Yes.
And did you then provide forensic training?
I have. Ever since then, I trained CPS workers, police, forensic interviewers employed by the Child Advocacy Center, and other prosecutors.
Are you familiar with the Kids Talk Child Advocacy Center?
Yes, it's the Wayne County's forensic interviewing site. Yes.
And explain how that works. Why is there a site for forensic interviewing?
So not every county in Michigan has a site, but those that do have a center where it varies from county to county, but at the Wayne County site, it's a one place that fits all. They have counseling, they have child advocacy, they have family advocacy, support groups, and forensic interviewing in that building.
Okay. By saying they have forensic interviewing, are there certain people who are designated as the interviewers?
Yes, there are specialized trained people. Most of them have master's degrees, and they are specially trained to learn the forensic interview protocol and to follow it.
Did you have a relationship yourself with that center?
I did.
And what was your relationship with it?
I was a contractual employee from April of 2016 until the pandemic started, and I think I'm still under contract in spite of the pandemic. My job was to meet one-on-one with the forensic interviewers and to go over their recordings, to critique them and to help them improve their skills. I also conducted trainings for the forensic interviewers about specific topics that were particularly difficult for interviewers.
Okay, with that background in mind, I now want to turn your attention to this particular investigation. And is it a fair statement that this investigation into allegations that Judge Green was aware that her grandchildren had been abused, that was of particular interest to you given your background with child abuse cases?
Yes.
And did I assign you to work this investigation?
You did.
As part of this investigation, did you interview both Russell and Max?
I did, on September 9th of 2019.
And did you interview them on occasions other than September 9th, 2019?
Yes, that was the first time. I also interviewed them in June of 2021, twice Russell and I believe once Russell and twice Gary.
And what were your reasons? I guess there may have been multiple reasons. So what were your reasons for interviewing the boys?
So in September of 2019, we became aware that there was an allegation that Judge Green put makeup on the boys' faces and was aware of physical abuse of the boys. We got a request for investigation, and the source remains anonymous. So the case was assigned to me, and as part of my investigation, I needed to interview the boys to see what they knew about all this. So that's why they were being interviewed.
That's why you interviewed them the first time, and then you interviewed them after that as well. Is that correct?
Yes. So I interviewed Russell in June, I believe, to get him prepared to testify at this hearing. And I interviewed Max because we learned that Max had written a letter potentially recanting the allegations against his father of child abuse and saying that his mother forced him to say this. And we had been told that Judge Green may have been the person who urged him to write this letter. So I wanted to interview Max about that to see if there were additional charges perhaps we needed to add to our complaint, or to determine what Judge Green's role it was in that situation.
When you interviewed the boys on each of, I think you've identified 5 occasions total when you interviewed them. 2 early on, 2 to get them ready to testify, and once to talk to Max about this letter. Is that accurate?
I believe so.
On the 5 occasions when you interviewed them, did you follow the forensic protocol?
Yes, every time.
Did you do something called hypothesis testing?
Yes.
What is hypothesis testing?
So Your Honor heard Nancy Deal describe it, but I will also describe it. The goal of hypothesis testing is to determine whether there is an innocent explanation for what a child says happened. So my hypothesis testing involved first asking the boys if they knew why they were there for my interview on September 9th. The reason I asked that was to determine whether their mother, who was their custodian at the time, told them what the interview was going to be about. I purposely did not tell Ms. Bressler why I wanted to interview the children. because I didn't want there to be any chance that she could have told the boys what the interview was going to be about. So I told her to tell the boys that they were coming to Kids Talk to talk to a nice lady. And I don't know if I'm nice, but that's what she told them. So the purpose behind that was when I asked them, do you know why you're here to talk to me today? They both told me they did not know. And that helped me to determine whether or not they had been coached by anyone, including their mother, about what the topic of conversation would be. Next, I had to establish what my hypothesis testing was involving the makeup situation. So I had to come up with some innocent reasons why a grandmother would put makeup on their grandchildren. And I came up with two. One was that it was Halloween time and she was helping them dress up in their costumes. The other was that perhaps the boys were in a school play and maybe they needed makeup for their play. So those were the two hypotheses I came up with for that. I also formed hypotheses.
And then is the idea to suggest to them or ask them whether this might be the reason why the makeup was put on?
Yes, and give them the opportunity to tell me, yes, that is why the makeup was put on me, or no, that is not why. And I did that. I also had to formulate hypothesis testing for the allegation that Judge Green knew the children were being abused. And I asked the boys about their relationship with Judge Green, how they felt about her, to determine whether they had a motive to lie about her. And I also asked about whether anyone told them what to say or what not to say. And I was trying to determine there whether anyone was coaching them to lie about her knowledge.
And did the boys say anything that triggered any alarms in your mind as you tried to find out whether there was coaching or motive to lie?
No, neither one of them gave me any reason to believe that they were lying about Judge Green.
I sort of interrupted you. Was there anything else that you wanted to explain about the hypothesis testing or the approach you used?
I don't think so.
Okay. Now, you did hear Nancy Deal testify, right?
I did.
You know Nancy well, is that correct?
I do.
Are there ways in which your interviews of the boys differed from what Nancy Deal described as the proper forensic protocol?
Not in any significant way, but I believe on cross-examination or redirect examination, Mr. Ashcraft pointed out that in this case, the children were interviewed or Max was interviewed at his home. And that is true. I interviewed Max twice at his home. The protocol does not require that a child be interviewed at a child advocacy center. All that it requires is that there be a child-friendly room that is not too distracting. So I interviewed Max twice in the basement of his home.
When you say his home, whose home was it?
It was actually his great-grandmother, Patricia Peak Russell's home, but it was where he was living at the time.
Okay. So anyway, I interrupted you again. You interviewed him twice in the basement of Ms. Peak Russell's home.
Yes, and I interviewed Russell at the Livonia City Hall. It was because it was after hours and it was somewhere convenient for his stepfather to bring him for me to interview him.
And why is it that you interviewed Max in the basement of Ms. Peak Russell's home?
So Ms. Peak Russell is an elderly woman who did not have a car, and it would have been very difficult to transport Max from his home or her home to either Kids Talk or to our office or anywhere else. So for the convenience of the elderly grandmother, we did it in her home.
And based on your experience with the forensic protocol, was there anything about that basement setting that conflicted with an appropriate location for an interview of this nature?
No, we were alone in the room. It was not a distracting room, and Max was able to focus, as was I.
Now, during the proceedings, you've heard Mr. Ashcraft comment several times on the raw number of times that the boys have been interviewed. First, can you just explain why it would even be a concern whether the boys are interviewed more than once? Why would that be a concern?
The only reason it would be a concern is if any of the interviewers were biased or planted ideas in the children's heads. If you read all of the interviews or watch the discs or read any of the transcripts, you will see that none of the interviewers asked leading or suggestive questions of the boys. So the fact that there were multiple interviews, even as many as Mr. Ashcraft pointed out, if there were 12, that's not a concern because none of the interviewers in any of those 12 interviews asked leading or suggestive questions.
And let me ask you if there were reasons particular to this overall investigation. Now I'm including the first allegations of child abuse all the way through what we're doing here today. Are there reasons that are kind of unique to this overall investigation that resulted in so many interviews?
Yes, it is not uncommon to have a child testify relating to a criminal case and also to a case involving the juvenile court. That is not unusual. But what is unusual is to have a child also have to testify at a Judicial Tenure Commission hearing. And then if you add to that what we learned about the Dear John letter, that required multiple interviews of Max to get to the bottom or the truth of what happened there. So in this case, it was unusual, but a review of the transcripts and the videos show that there was no leading or suggestive nature of the questions in any of the interviews. So I have confidence that all of the interviews elicited non-leading, non-suggestive, truthful answers.
Is it consistent with the protocol to do multiple interviews if the focus of a later interview is different than the focus of an earlier interview?
Judge, I'd like to object here, please.
Yes.
This has clearly left the realm of a fact witness and has now entered clearly into the realm of expert testimony.
Thank you.
She's not been
Response?
identified.
No, go ahead and finish.
She has not been identified as disciplinary counsel also serving the role under a different hat of an expert witness in this case.
All right, thank you, Mr. Helen. Response?
Yes, Your Honor, I believe that the qualifications that she has described for herself, where she was trained early in the protocol, has been a trainer under the protocol for years, has done thousands of forensic investigations, reviews the forensic protocol followed by other people in order to critique it, establishes that she is familiar enough with the protocol to be an expert with respect to it.
All right, thank you. Continue, Mr. Ashcraft. Any further objections?
Yes, Judge. I'm now getting this notice on rebuttal. If that's the case, and I knew that there was a chance that Ms. Weingarten was going to be opining with regard to not only facts, but also expert opinions, I may have taken a different approach with Ms. Steele and asked her additional questions related to what Ms. Weingarten did. I didn't have that opportunity. She's never been identified in this case as an expert witness until literally just now.
Mr. Ashcraft, did you have objection to the questions before this very last one that Mr. Helen asked that may have been moving a little further into that? Did you have objections before then?
To be candid with Your Honor, I don't remember exactly what the question was. It's just when I tracked it, realized it's clearly gone afield.
Mr. Helen, if you remember your last question, would you ask that again and let's hear it?
Yes, Your Honor. To the best of my recollection, my last question had to do with the whether it is consistent with the protocol to interview a subject multiple times where the focus of a later interview is different than an earlier interview. So the thing I just phrased that awkwardly, but the thing I'm trying to get at is, are you complying with the protocol if you interview a child multiple times, but the reason you do so is because the interview has a different focus than an earlier interview?
And Mr. Ashcraft, to that question, do you have an objection?
I do, Judge. I believe it's specifically asking an expert opinion question, and it doesn't tack back to any specific facts in which Ms. Weingarten was involved. It's asking for opinion testimony.
All right, I'm going to overrule the objection at this time. There might be an additional one depending on where you continue to go, Mr. Helen, but I will allow you to ask that question.
Thanks. Actually, I think that's probably my last question. Thank you.
So the answer is the protocol in Ms. Steele's testimony allows for multiple interviews if the subject or the topic of the conversation focuses on a different perpetrator or a different allegation of abuse. So I think we've complied with the protocol.
Thank you. Your Honor, I've got no further questions for Ms. Weingarten.
Thank you, Mr. Ashcraft.
Thank you, Your Honor. Ms. Weingarten, you interviewed Gary Jr. in his home, right?
Yes.
And on the phone, right?
Yes.
And also at the Kids Talk facility, the Child Advocacy Center,
Yes.
right? And then someone from your office also picked him up and drove him to the offices of the Michigan Judicial Tenure Commission for purposes of testifying in this formal hearing, right?
Yes.
Now, you said that you were sure there were no leading or suggesting questions in the 12 interviews that were conducted. But there were more than 12 interviews, were there not?
Not that I know of.
Well,
I haven't counted them, but I was using your number when you cross-examined Nancy Deal, when you direct-examined Nancy Deal.
actually what I said was more than 12.
Okay.
So they were interviewed by police officers, right?
If you call that an interview,
Excuse me, am I right?
well, are you talking about a forensic interview or an on-the-scene interview?
An on-the-scene interview.
Yes, a police officer talked to
Thank
the
you.
boys.
And they were also interviewed by defense lawyers, right?
In court, you mean?
In court,
Yes.
in preparation for court testimony, right?
Well, I don't know about in preparation for court testimony, but they testified on the record in juvenile court and criminal court.
You don't know how many, they were interviewed by Mr. Elric, weren't they?
Yes.
And you don't know whether or not any of these people that I just identified asked leading or suggesting questions, did you?
I do not know that.
Now, you indicated that you're a contractual employee at Kids Talk. During your time as a contractual employee at Kids Talk, is it fair to say that your role was limited to training other interviewers?
Yes.
Did you conduct any interviews yourself at Kids Talk as a contractual employee other than Gary Jr. and Russell?
No, but I did
Thank
not do that in my
And as-
capacity as a contract employee. I did it in my capacity as a staff member of the Judicial Tenure Commission.
And the Judicial Tenure Commission is recognized as an acceptable agency to come in and use Child Advocacy Center's facilities?
Well, I don't know if the agency is, but I asked for permission and they granted it.
So you asked for a special exception, is that right?
I simply asked and they said yes.
You're not aware of any rule or policy that permits the Michigan Judicial Tenure Commission to go in and use the Kids Talk facility to interview witnesses, correct?
I am not aware of a policy.
Or a rule that allows that, correct?
I'm not aware of a rule either.
Thank you. You did it because you knew the people there, so you went and asked permission to bring these boys into this facility that has cameras in the corner and contact microphones all around, so you could sit them and have them sit them down and have them recorded in that atmosphere, right?
Yes.
How did you obtain the videos of the boys' statements or the interviews that you took?
Immediately after the interview was over, they make discs, and I believe I asked them to make each of us, you and me, a disc of each of the boys' interviews.
So you're the custodian of the record?
I have one copy of each of the boys' interviews, and I believe you do too.
The custodian of the video recorded statement means the Department of Human Services, investigating law enforcement agency, prosecuting attorney, Department of Attorney General, or any other person designated under the county protocols established as required by the Child Protection Law, right?
Well, you're reading from MCL 600.2163A, which relates to a normal police and CPS investigation. What we did was not that. Our investigation was from the Judicial Tenure Commission.
But Michigan Judicial Tenure Commission is not recognized under the statute as being someone who can be the custodian of the record from Kids Talk, correct?
Not if there's a police or CPS investigation. That is correct.
Well, so we know that doesn't involve that. This is an administrative proceeding for the MJTC, right?
Yes.
We're clear on that?
Yes.
There's no statutory authority that allows the MJTC to use the facility and then be the custodian of the record. Do you agree with me?
Yes, and there's also no rule that prohibits it.
I see. So your role as an investigator in the MJTC case is not deemed by law to be among those who can be the custodian of the record, correct?
I don't know that to be true.
And you don't know it. You don't know that to be true, what I just said?
Correct.
You're not aware of any rule or statute that allows the MJTC to be the custodian of the record. Can we agree on that?
Yes, but I don't know of a law that prohibits it either.
I see. Michigan law requires that in each county, the prosecuting attorney and the department, which is the MDHHS, develop and establish procedures for involving law enforcement officials and children's advocacy centers as appropriate, correct?
Yes,
And the prosecuting attorney office or the department are required by law to follow the established procedures for involving a child advocacy center, correct?
yes,
And those procedures for involving the child advocacy center do not allow for just anyone who has been trained in the forensic protocol to engage and use the advocacy center for child interviews, correct?
I don't know that to be true.
And you don't know that any rule allows it to happen, is that right?
I think it was at the discretion of the director.
So if I would have gone in and asked for an opportunity to examine any of my witnesses, including the boys, for example, would the child advocacy center allow me to do that?
I don't know.
How many forensic interviews did you conduct of the boys,
Every time I talk to them,
including on the telephone?
no.
So
On
how
the
many
telephone-
forensic interviews did you conduct of the boys?
With Gary, the 9/9 of 19, June 1 and June 11th. With Russell, 9/9 of 19, and I think it was June 10th of 19.
How many other in-person interviews did you have that were not forensic?
None.
How many phone interviews did you have that were not forensic?
I think I had one phone call with each of them, maybe two.
Now, you shared with Mr. Helen that there are two overriding features of the protocol, right? That's hypothesis testing and a child-centered approach.
That's two of the factors, yes.
And it's in the alternative hypothesis and hypothesis testing phase where you rule out other possible motivations or reasons for the child to make statements about abuse by adults. Is that right?
Yes,
And the protocol expressly requires ruling out coaching, retaliation, and desire for alternative living or visitation arrangement, doesn't it?
yes,
And you knew in this case from the beginning that Judge Green had specifically raised coaching and grooming by the mother, Corey Bressler, as well as the boy's desire to live with her after 3 years of abandonment in this MJTC case, correct?
I don't know if I knew that before I interviewed the boys for the first time.
Did you know that when you interviewed the boys the second time?
By then, yes.
Thank you. So I want to ask you how you tested the hypotheses on coaching.
So the first thing I did when I met them on September 9th was ask them whether they knew why they were there to talk to me. And they both said they did not know. So it led me to believe that their mother did not, their mother and no one else told them what the topic of conversation was going to be. I also asked about how they felt about Judge Green, what they liked about her, what they didn't like about her. They were both able to tell me nice things she did for them. I asked them if anyone told them what to say or what not to say, and they both denied that anyone told them what to say or what not to say. And neither one of them gave me any reason to believe that they were out to get Judge Green or they were mad at her or anything like that.
That's the extent of your hypothesis testing regarding coaching.
Yes.
Did you ask any separate questions regarding grooming?
What do you mean by grooming?
Grooming, where a mother in this particular instance was grooming the children over the course of time to come up with particular answers, gauged to a conclusion that she had.
Okay, so first off, I have never heard that word used in that context before, and I don't even understand what you're saying.
So you've never heard the word grooming as relates to the forensic protocol?
Correct. I've heard the word grooming about sex offenders who are grooming children to submit to abuse.
Did you hear Ms. Deal talk about grooming?
Not that I recall.
What about questions related to desire for alternative living or visitation arrangements? Did you ask any additional questions with regard to that?
I did not, because Judge Green was not a parent or guardian who the children would be living with.
I see, which obviously is different because this is an MJTC proceeding as opposed to a criminal proceeding involving the health, safety, and welfare of a child, right?
Yes.
What about questions in addition to what you said related to retaliation against the accused? In this particular instance, Judge Green.
Yes. So I asked the boys, as I've said, how they feel about her, nice things she did for them, things that she did that weren't so nice. And I believe I asked them whether they're saying this about Judge Green because anyone told them to say it, and then I also asked them, is everything you've told me the truth? And is there anything you've told me that is not the truth?
Now, during at least 2 of your interviews with Gary Jr., you were told a lie, weren't you?
Yes,
It was a big lie, was it not?
it was.
And as a matter of fact, when he came and told you that, off the record, so to speak, you told him, we'll get back on the video and I will summarize it for you, and you can indicate that whether I summarized it correctly, right?
Well, no, that's not how it happened.
Well, let me ask you this. Is that exactly what you did do? You summarized on the video what the circumstances were related to the lie, and then you asked him if that was correct?
So I can't answer that with a yes or no. I would have to expand on my answer. May I do that?
No, thank you. I think the video indicates what you did. Now, Ms. Deal is a mentor of yours, yes?
She was. She's retired now.
Right. You do consider her an expert in the forensic protocol and child welfare matters,
Yes,
correct? You actually stipulated to that on the record when she was being examined, did you not?
I did.
You heard her testify?
Yes,
You heard her question, let's write that. You heard her question the veracity and reliability of the boy's statements after more than a dozen interviews, did you not?
no, I don't recall that.
You simply have a difference of an opinion with regard to her testimony, don't you?
I don't understand the question.
You also indicated to Ms. Deal testified that she had a problem with Gary being interviewed at home. Remember that?
Yes,
But you didn't have a problem with it, did you?
correct, I did not.
So you think that her opinion on that was just wrong?
Well, I think if she understood the transportation issue and the fact that he lived with an elderly grandmother who didn't have a car and didn't have transportation, and we were trying to make this as convenient as possible for her, I think Ms. Steele would have said she understands why we did it this way.
But you never asked her that question, did you?
I did not.
And to date, you've never asked her that question, have you?
I have not.
You have no basis for your speculation as to what she would have said about that, do you?
Well, I know she's a decent human being, and I believe she would have wanted to accommodate an elderly woman.
Well, is decency something then that trumps the best practices under the forensic protocol?
Sometimes.
I have no further questions. Thank you.
Is there any redirect?
Just briefly, Your Honor, Ms. Weingarten, Mr. Ashcraft deprived you of the opportunity to explain what you did in connection with Max after you realized that, and he acknowledged that he had made a false statement to you. Could you please go ahead and explain that?
Yes. We ended our interview in the basement. I turned off my computer and turned off Zoom. I was packed up and I was literally 3 inches from the front door of his home when he said to me, "Oh, I found the letter that I was referring to, and that's the Dear John letter." So we went into his kitchen and we talked, and he found it on his computer, and we talked further. And that's when we went on speakerphone with a Detroit police officer to ask him what information he needs in order to get a search warrant for Gary's computer and his father's computer. And then once we did that, that's when Max came clean about the fact that he had lied. I think he got nervous when he heard that we were going to get a search warrant. We were going to get to the bottom of this, and that's when he came clean. So eventually I turned back on my computer, we went on Zoom, and I summarized what happened, and I got him to confirm that what I've said was accurate. And we provided Mr. Ashcraft with that Zoom, and I believe it's going to be marked as an exhibit in this case also.
And was there anything that you summarized inaccurate?
Not that I'm aware of.
No further questions here.
Mr. Ashcraft, any final questions?
Just one. Ms. Weingarten, why didn't you go to Child Advocacy Center for all your interviews?
Why did we not?
Why didn't you?
Because Max did not have transportation.
But you picked him up and brought him to MJTC to testify in this formal hearing.
I did not.
Someone from your office did.
Yes.
You couldn't make that arrangement for him again in light of the circumstances of the elderly grandmother?
I don't recall being involved in any discussions about doing that.
Thank you. I have no further questions, Your Honor. Thank you, Ms. Weingarten.
All right, thank you. May this witness be excused with
Yes, Your
respect
Honor.
to the testimony. All right, thank you. You are excused. Additional witnesses from the disciplinary council.
None, Your Honor.
Thank you. Rebuttal witnesses, if any. Mr. Ashcraft.
None, Your Honor. Thank you.
All right, thank you.
Judge, we have some exhibits that I think we're stipulating to their admission.
All right, why don't you mention those and we'll see?
Okay, Exhibit 44 is a Zoom interview that I did with Max on June 1st of 2021. Counsel, any objection to its admission?
No, no objection, Your Honor.
It is
Exhibit
admitted.
45 is a Zoom interview I did with Max on June 11th of 2021, and it's a two-part interview.
No objection, Your Honor.
All right,
Exhibit number 46 is a Zoom interview I did with Russell on June 10th of 2021.
No objection, Your Honor.
Exhibit 48 is a document, a court order from Judge Kevin Cox dated June 1 of 2015. It's a judgment of divorce.
No objection, Your Honor.
And Exhibit 49 is a temporary custody order signed June 17th of 2018, signed by Judge Adele, A-D-E-L, Harb, H-A-R-B.
No objection, Your Honor.
those are all admitted then. What happened to Exhibit 47? Which one is that? I just see that there's a gap.
There will be a lot of gaps, but look. Judge, that was Judge Cox's April 30th, 2015 motion transcript. Based on your ruling this morning that the 28-day letter does not come in, Mr. Ashcraft and I talked and we agreed that that transcript cannot come in.
All right, thank you. All right, so counsel, we are finished with the testimony for this matter, and now we have the closing arguments. Our plan was to have those today immediately, and so that is what I am ready to do. Are you ready to do that, counsel?
Yes,
Yes. Does either side need to take a break before we do?
I do not.
I think we're good, Judge. Thank you.
All right, thank you. We had talked about the time that you expected to take for your closing arguments. Do you have any revision of that at this point?
I think mine will take the whole hour that you allotted.
All right. And Mr. Ashcraft, you had indicated you expected yours to be about an hour.
That's correct, Judge. We were capped at an hour. I don't know exactly where mine is, but
All right, let's go off the record for a little bit.